pursuant to adjournment. The Honorable Visiting Judge, Guy Reese, presiding. Please be seated.
Thanks, Mark.
Michael Amiott, to the podium, please.
This matter is set for arraignment in one case and also just basically a status or pretrial in the other case. Counsel, how do you wish to proceed at this time?
We acknowledge receipt of the charges and enter not guilty.
Very good. The court at this time will enter a not guilty plea. We need to address the next date for this matter, trial date, and after consulting with counsel and chambers, it appears that the best date for me is the 20th of November. Now, I understand that there will be some preliminary matters that must occur prior to that, or prior to us proceeding to trial, but it would appear that for me, that's the best date at this time. That is a Wednesday, which is a little bit unusual in that most trial dates start on Monday here. But I believe the court will be able to accommodate us if we proceed with that date. We also discussed in chambers speedy trial, and there were a number of incident issues in this case. My understanding is that the initial filing in this matter occurred in August or September? August. And at that time, Judge Gallagher, who was the assigned judge in this case, recused himself, and then the matter was referred to the Supreme Court, and the Supreme Court took some time in which to appoint me as the visiting judge in this case. We were initially set for arraignment on the 8th of November. However, due to my scheduling conflict...
I think you mean October 21st.
21st of October. Because this is the 8th of November. 21st of October. Thank you, Counsel.
Yeah, and just to make the record clear, I think initially we were set September 12th and then October 21st.
Okay. October 21st, which was a conflict for me, in that I was assigned to another court in a different jurisdiction. And therefore, based upon that, I continued this matter until today for us to be here today. My understanding is that based upon all of the things that have occurred in this case, the recusal, the filing at the Supreme Court, and then my own personal issues with respect to prior assignments, I know we may have eclipsed that traditional 90 days, but I believe based upon all of those occurrences, that's an issue that's really not an issue. However, I understand that you may want to proceed with a motion, and that's totally within your rights.
Yeah, I mean, it's our position that it's been more than 90 days since the date of service, and so we will be filing a motion on that issue, and of course, we'll expect the courts.
You'll expect the court to rule accordingly. Counsel, anything on behalf of the state?
Your Honor, the only thing I would add to that issue is that I don't think that we have so-called eclipsed the, and I say that respectfully, eclipsed the speedy trial time, because there are two journal entries in this case. There's a journal entry in each case, under each case number, journalized October 17, 2019, that reads as follows. Visiting judge being unavailable for arraignment scheduled for Monday, 10/21/19 at 10 a.m. parties have agreed to reset to Friday, 11/8/19. So if you count the days from 10/21/19 to 11/8/19, that is 10 plus 8, that's 18 days. So I think the date that we've selected, which is 20th of this month, which is 12 days from today, is...
Any other preliminary matters on behalf of the state?
No.
On behalf of Mr. Amiott?
Amiott. No,
Amiott.
Thank you.
Nothing?
Nothing. Thank you.
Very good. We will set this matter for trial on the 20th, realizing that in all likelihood we will move it from that date at 9 a.m. That's all?
Thank you, Judge.
Thank you.
All right.